Hi again. So, as promised, I will be starting the Civil Law Review playlist this week. So, parang every weekend na lang siguro ako mag-upload ng lecture videos kasi I need like a week to prepare the notes. Yung notes ko, compilation siya ng notes ko from law school, bar review materials, and ayun. So, kino-compile ko siya and pinipili ko yung important and ina-update ko rin siya kasi syempre, may mga changes din naman and dapat, since we're taking the bar, updated. Okay. So, for the civil law review, I'll be discussing the general provisions of the new civil code, followed by persons, and then the family code. So the family code will include topics on marriage, property regime, children, parental authority, support, family home, ayun, baka may nakalimutan ako, basta i-cover natin lahat yon. And after that, we will pause civil law review and I will start with political law review. Consti 1, yun muna. And then, after Consti 1, I'll be going back sa criminal law review. So, my last video on that playlist was up until alternative circumstances and absolutory causes. So, I believe the next topic is extinction of criminal liability. And then, after that, tapos na natin yung book 1 ng revised penal code. Kapag umabot tayo doon, discuss na rin natin yung penalties. Before tayo mag-proceed sa book 2, I'll go back dito sa civrev playlist and then we can start on property. Tapos after ng property, tapos natin yung polyrev up to Consti 1 and probably start Consti 2. So kasama dun yung Bill of Rights. Basta yung goal is matapos natin yung polyrev then up to December. And hopefully including topics on public international law. And then, magki-crim 2 na tayo dun sa crimrev. Tapos dito sa civrev, after ng property, succession. And then, sa polyrev, after ng Consti 1, Consti 2. And then, public, i-rotation natin yung crim, civ, and poly. And hopefully matapos natin hanggang December yung criminal law review and political law review plus public international law. Yung sa civ parang malabo kasi sobrang daming topics sa civ. So baka 2024 na natin start yung other topics on civil law like obligations and contracts, sales, cred trans, land titles, isama na rin natin. So, yon. Baka may nakalimutan ako, basta isasama natin lahat yan. And then, magko-commercial law tayo. Tapos, tax law, labor, and of course, remedial law. And judicial ethics. May nakalimutan ba ako? So, pag may nakalimutan ako, hayaan nyo na. Basta yun yung goal. Hopefully matapos natin lahat. Okay, so I guess start na tayo. Dito sa video na to, I'll be discussing general provisions of the new civil code. So first, when do laws take effect? Okay, yung how laws are created, poly na yon. Pero basically, laws are created sa Congress. Okay, gagawa sila ng law doon. I-discuss natin sa polyrev kung paano exactly gumawa ng law, how a bill becomes a law, etc., etc. But the point is, bakit civil law is, we start with when laws take effect. Kasi, kailangan natin malaman, di ba, ignorance of the law excuses no one. However, if hindi na-publish yung law, how are we supposed to know, di ba? Hindi naman pwedeng walang publication kasi people are not expected to know na may law na pala if it wasn't published. So it's important that the Congress also complies, or the government also complies with the publication requirement, so that the people are apprised of what laws are, and so that they know, diba? So that they know that there's a law, and that doon na mag-a-apply yung ignorance of the law excuses no one from compliance therewith. So, laws shall take effect in general after 15 days following the completion of their publication in the official gazette. Yun yung parang newspaper ng government. Or siya hindi kailangang official gazette plus a newspaper of general circulation. Either. Pwedeng dalawa, sure, pero either is fine. Unless it is otherwise provided. So, anong ibig sabihin ng unless it is otherwise provided? It refers to the date of effectivity of the law. Meaning, legislature can either shorten or lengthen the sinabi ko kaninang 15 days following the completion of the publication. It doesn't have to be 15 days. So, the law or the statute can state there that this law shall be effective 30 days following completion of publication. Pwede yung ganunin. Or 10 days, or effective immediately after publication. Parang ganyan. Hindi pwedeng i-dispense yung publication requirement. Yung unless otherwise provided does not refer to the publication requirement. It's required. Kasi how are people supposed to know about the law? How are they supposed to follow it if they don't know it exists? Okay, so it's just fair. That's the thing about civil law, then it makes the most sense for me out of all the kinds of law. Anyway, the publication of municipal ordinances is covered by the Local Government Code of 1991. So let's define what a year is. So, nung elementary ako, sinasabi na yung year 365 days and 1/4, may mga ganong pa. So, it's simple now because Article 13 of the new Civil Code has been superseded by Executive Order number 292 or the Revised Administrative Code of 1987. So, now pag sinabi mong year, okay, it means 12 calendar months. January to December. So, hindi ko na iisa-isahin kung ano yung 12 months of the year. Kasi, hindi naman tayo aabot ng law school kung di natin alam yon. Okay. How about a month? So, some months, di ba, 30 days, 31 days. So, pag merong term na month na makita ka sa isang contract or sa isang law, what does it mean? It means 30 days. Hindi na tayo, yun na yung presumption. Hindi na tayo mag-aano na 30 ba or 31? Bakit hindi nasabi? Hindi ganon. 30 na agad yun pag month lang. Unless, so merong unless, the month is identified. So pag sinabi month of May, 31 days yun. So hindi mo sasabing 30 days lang kasi month is 30 days daw sabi sa batas. Hindi. Kasi naka-identify na yung May eh. Or, last month of the year, hindi sinabing December, pero alam naman natin na December yung last month of the year and December has 31 days. So, kung identifiable naman kung ano yung ibig sabihin mong month, hindi mo sasabing 30 days. Yung a-apply mo is 31 days kasi 31 days naman talaga sa December. So, meron ding instances, kasi I work as a legal associate and very particular yan when it comes to dates. Kasi, compliance eh. Kapag ka nag-exceed ka dyan, merong pwedeng deemed waived yung certain rights mo, or hindi ka na makakatanggap ng bayad, or kailangan mong magbayad sa ganyang araw, or else kapag hindi ka nakabayad within that period, babayad kang interest. So very important yung dates. So pag sinabi mong 3 months from the date of execution, yung date of execution, yun yung date kung kailan nagkapirmahan ng kontrata. So, kunwari September nagkapirmahan, sabihin mo 3 months from the date of execution, kailan yon? So, hindi ka magka-count ng 30 times 3, 90 days from the date of execution or the time that the contract was signed. For example, September 23, papahirapan mo yung sarili mo na magka-count ka pa ng 90 days therefrom. Hindi. Tsaka hindi rin siya magiging accurate. 'Di ba? Kasi yung October, ilang araw meron yung October? May 31 days yung October. So hindi magiging accurate yung 90 days mo kung 3 months therefrom. So dahil alam mong September yung date of execution, kahit hindi sinabi or hindi in-identify yung months, alam mo na yung kasunod ng September is October, November, December. So, ganun yung pag-count mo ng 3 months. Okay. So, let's go naman sa day. Pag sinabing day, of course, 24 hours. Wala nang question. Iba yung daytime sa day. Pag sinabi mo kasing daytime, it's sunrise to sunset. And if you're being very particular, iba-iba yung time kung kailan yung sunrise at sunset. Diba? Nag-iiba-iba yon. Kapag night naman, it's sunset to sunrise. What do you mean by calendar week? When you say calendar week, it's Sunday to Saturday. So, most of us merong misconception. Akala natin, Monday is the first day of the week dahil yun yung first day na pupasok tayo sa work or pupasok tayo sa school. But, really, when you officially, yung start of the week is the Sunday. So, when you say second week of the month, you start dun sa second Sunday of the month, as the case may be. Kasi hindi naman sakto yan na baka hindi naman saktong Sunday to Saturday lagi yung when the first day of the month falls sa particular month, 'di ba? So kunwari sa September, kailan yung second week ng September? So yung September merong 5 weeks actually ng September. So lagyan natin 4. So yung sabihin natin yung first ano sabi ko kanina, second week of the month, that would be second week of the month, that would start Sunday kasi yung start ng calendar week. Tama. 4 weeks lang pala. Sorry pala. Since Sunday siya magsa-start yung calendar week, so yung first week natin ng September is on a Sunday, September 3, and then the second week would be September 10. Yan. Okay. So, pag sabi mo naman calendar day, usually sa practice, binibilang mo lahat ng araw, hindi mo ini-include yung Sunday at saka legal holidays. Lahat ng araw included sa pagbibilang mo pag calendar day. Week, count 7 days as indicated. So, date of execution, hindi mo ilalagay sa Sunday, hindi laging ganon. Date of execution mo, September 23. 7 days therefrom, magka-count ka ng period ganito. First day is excluded, last day is included. So, dahil first day is excluded, last day is included, 7 days from September 23, okay, is 1, 2, 3, 4, 5, 6, 7. September 30. Yun yung a week from now. Okay? Pretermission of holiday. What do you mean by that? So, in an ordinary contract, the general rule is that an act is due even if the last day is a Sunday or a legal holiday. With certain exceptions. Kasi sa contract, hindi tayo mag-o-oblicon, pero general provisions, sige, discuss natin ng konti. law of the contracting parties yun eh. You can stipulate whatever you want. As long as it's not contrary to law, public morals, public order, ganon, customs, mga ganyan. So, pag sinabi mong 7 days from date of execution is, ano yan? Isasama mo, without consideration yun sa Sunday or legal holiday. Unless, nilagay mo dun sa contract working day. Usually, pag working day, hindi kasama si Sunday at saka si legal holiday. Pag sabi mo naman calendar days, para mas specific ka, included talaga si Sunday or legal holiday. Pero, kasi sa contract, i-define nyo naman yan eh, kung what is a week to you, what is a day to you, depende. Merong portion yan. Pero pag hindi nakastate sa contract, the civil code applies suppletorily dun sa contract. So, parang yun yung parang guiding light mo. Ano ba ibig sabihin ng day dito? So, sabi sa civil code kasi ganito yung day. Ganyan, or ganito yung week. On the other hand, when the time refers to a period prescribed or allowed by the rules of court, by an order of the court, wait lang, babalikan ko lang sa apply suppletority kasi baka isipin nyo. Of course, kailangan ng contracts mag-comply sa civil code dun sa obligations and contracts. So, what I mean to say is that if there is something missing or something ambiguous dun sa interpretation of the contract, then you take the definitions from the civil code or how the civil code defines certain things. Yun yung pagde-define mo doon sa kontrata. Sa mga terms na parang ambiguous dun sa kontrata. Anyway, moving on. Period prescribed or allowed by the rules of court, by an order of the court, or by any other applicable statute, if the last day is a Sunday or legal holiday, it is understood that the last day should really be the next day, provided that the said day is neither a Sunday nor a legal holiday. So, usually kapag issuances galing sa gobyerno, pag sinabi lang na day or week, hindi na sinasama kapag may obligation, for example, babayad ka ganito, hindi na kasama si Sunday at si holiday kasi walang office ng time na yan. Unless, of course, the law stipulates otherwise. So, what do we mean by newspaper of general circulation? Balikan natin yung sa kanina. It is enough that a newspaper is first published for the dissemination of local news and general information. So, hindi kailangang national newspaper. Okay, local news and general information. Second, that it has a bona fide subscription list of paying subscribers. And third, that it is published at regular intervals. So, the term newspaper of general circulation does not mean that it is a newspaper with the largest circulation. Hindi kailangang Philippine Star. Hindi kailangang Philippine Daily Inquirer. Hindi kailangang Manila Bulletin. The fact that there are other newspapers having larger circulation is unimportant. You can publish your law sa mga other newspapers of general circulation or other newspapers dyan. Alright? So, statutes that must be published. The following require compliance with the publication requirement. First, those of local application. Even the charter of a city needs to be published. Second, private laws, even those naming a public place after a favored individual or exempting him from certain prohibition requirements. Next is circulars of the monetary board. If they are not meant merely to interpret but to quote-unquote fill in the details of the Central Bank Act. And lastly, administrative rules and regulations if their purpose is to enforce or implement existing law. Okay. So, yon. Siyempre, laws passed by Congress must be published. Laws of local application, private laws, circulars of the monetary board, and administrative rules and regulations if their purpose is to enforce or implement existing law. Publication is not required. Kailan hindi required? Actually, mas okay na tandaan yung not required kaysa dun sa published. Kasi as a general rule, laws are to be published Hindi kailangan na mag-comply sa publication requirement yung Supreme Court decisions. Although it's available naman. Interpretative regulations. Kaya specific dun kanina sa circulars of monetary board na kailangan i-publish if it's not merely to interpret, but to fill in the details. So if it's only an interpretative regulation, publication not required. Letters of instruction issued by administrative superiors on rules or guidelines to be followed by subordinates in the performance of their duties, and those internal in nature, regulating only the personnel of the administrative agency. The date of effectivity of municipal ordinances is not covered by the rule and publication but by the local government code. And administrative rules and regulations must also be published if their purpose is to enforce or implement existing law pursuant to a valid delegation. So yan, mga municipal ordinances. So balikan natin yung ignorantia legis non excusat. Ignorance of the law excuses no one from compliance therewith. A mistake of law cannot be utilized as lawful justification because everyone is presumed to know the law and its consequences. Of course, that's why may publication requirement. Mistake on a doubtful or difficult question of law may be the basis of good faith, sure, but still, ignorance of the law excuses no one. Ignorance of fact is different from ignorance of law because sa ignorance of fact, na-discuss ko na ito sa criminal law, achong case, no? It eliminates criminal intent. Pero may mga requisites yan. Hindi na ako magkikrim dito. So, panoorin nyo lang yung crime rev videos. But basically, meron niyang requisites para ma-appreciate yung mistake of fact na wala kang liability. Okay. Next is conclusive presumption. Every person is presumed to know the law even if he has no actual knowledge of the law. The presumption does not apply to foreign laws because there is no judicial notice of such foreign laws. Kaya nga, yung mga foreign laws, dapat i-prove mo pa sa court kung meron kang ini-invoke na entitlement mo sa foreign law. Kasi, hindi agad na nag-take ng judicial notice dun sa foreign laws na yun. Kailangan mo pang i-prove. For example, divorce, diba? Nag-divorce ka, gusto mong i-recognize sa Pilipinas. Kailangan mo pang i-prove yung divorce law sa ibang bansa by showing proof. Custom, rules of conduct formed by repetition of acts uniformly observed as a social rule. They are legally binding and obligatory. Requisites to make a custom an obligatory rule. Hindi porket custom nyo lang dyan or tradition mo lang dyan is okay na. Kaya may rules pa rin. So, kailangan i-prove na, you have to prove it as a fact. Prove that there is plurality and that there is repetition of acts. Second, prove that the community accepts it as a proper way of acting, such that it is considered as obligatory upon all. So, recently, merong mga issue about kulto-kulto dun sa Surigao daw. Kung ano man yung mga acts nila doon, hindi nila pwedeng i-justify as custom nila or tradition nila, even if it is cloaked sa religion pa. It's because you still have to prove it, and dapat nag-a-apply pa rin yung law sa kanila. Again, our laws apply sa everyone, especially the citizens and even those who just sojourn dito sa country. So, territoriality principle yan. Diba? Criminal law. But, yeah, hindi pwedeng basta-basta mo lang sabihin na, okay, this is a custom. So, dapat may repetition of acts and dapat the community accepts it. And dahil the community accepts it, it is obligatory upon all. And hindi pwedeng just a small group is practicing it. It must be practiced by a great mass of people or social group. And that, hindi pwedeng gawa-gawa ka lang ng custom dyan. It must be a continued practice for a long period of time. Parang tradition nyo na dyan. Uniformity or identity of acts or various solutions to the juridical question, and the practice must not be contrary to law, morals, or public order. Yung pinaka-importante, hindi lahat ng customs okay. Hindi lahat ng customs nire-recognize ng batas. Still, supreme pa rin yung Constitution. yung batas natin, yung mga human rights natin. So, kung custom nila dyan, magpatayan ng tao, hindi uubra yan. Hindi pwedeng i-justify yan na, ay, nagpapatayan naman kami dito since ilang dekada na, or isang century na kami nagpapatayan dito, or what, diba? Hindi pwede. Because it's contrary to law, public moral, or public order. So, if you're doing something barbaric there, or something very tribal that is shocking to the conscience, then that is saying that it is a custom will not fly. Judicial notice refers to the act of the court in taking cognizance of matters as true or as existing, or as existing without the need of introduction of evidence or the authority of the court to accept certain matters as facts even if no evidence of their existence has been presented. So, ang daming judicial notice. For example, when you say the city of Taguig, the city of Makati, nag-aagawan sila ngayon ng teritoryo, hindi mo na kailangang i-prove yung existence ng City of Makati and City of Taguig kasi the court should take judicial notice thereof. Okay? Kung ano yung mga facts dyan and existing sa science, sa history, and just the state of things, the court will take judicial notice. But there are matters that the court doesn't take judicial notice, such as foreign law, kasi andun yun eh. Hindi mo alam na agad ng courts yan. 'Di ba? Unless it's something like siguro mga amendments or parang counterpart ng Bill of Rights ng US, which is parang sometimes cited din sa Supreme Court decisions. I don't think that they prove it in court, but sometimes they cite it. So the court takes judicial notice thereof. Or kung ano yung mga ginagamit nilang parang sources in rendering decisions in case of insufficiency or to better interpret certain laws. Like for example, sa criminal law, sa revised penal code, they sometimes look at the Spanish criminal law or the Spanish revised penal code something, 'di ba? Kasi yun yung basis ng revised penal code natin. So they look into that. So they take judicial notice thereof. Hindi na yun piniprove in court. Okay. Doctrine of processual presumption. When a foreign law is not pleaded, or even if pleaded is not proved, the presumption is that the foreign law is the same as ours. In the following instances, foreign laws can be considered by the court even if not pleaded or proved. So, kung hindi mo ma-prove, madaming kaso yan eh. Like, this case involving, like, ewan ko kung tama pero sige, example nilang natin. Whether tama or mali yung facts ko, pero yung doctrine ko dito tama for sure. I'm confident. So, merong taga Netherlands, tapos meron siyang asawang Pinay, tapos nabuntis yung Pinay, nanganak, so half Filipino, half taga Netherlands, kung ano man tawag sa Dutch ba tawag sa taga Netherlands, so half Dutch, ganon. Tapos nag-divorce ngayon tong dalawa, si Pinay at saka si Dutch guy. And then, umuwi si Pinay sa Pilipinas with their anak. Tapos, nag-promise naman si Dutch daddy na magbibigay pa rin ng support, child support. Pero, hindi nangyari. Okay? So, si Dutch boy, Dutch daddy, mali sabihin, boy. Si Dutch daddy, bumalik ng Pilipinas, nag-establish ng residence dito, nag-asawa ng bago, tapos ngayon nalaman ng former Pinay wife and nagde-demand kayo ng support. Okay? Tapos sabi ni Dutch daddy na, well, sa Netherlands hindi kami required na i-support yung mga anak namin pero wala siyang pinakitang foreign law backing his statement na ganun. So, Doctrine of Processual Presumption, dahil support namin yung mga bata dito, let's assume na yung law mo dun sa Netherlands ganun din. So, pinabayad pa rin siya ng support. Isa yun sa mga doctrines ng kaso na yun. Lex Loci Celebrationis. Forms and solemnities of contracts, hindi yung substance niya, yung form lang. Okay? Wills and other public instruments, extrinsic lang, hindi intrinsic. Extrinsic validity lang. Shall be governed by the laws of the country in which they are executed. Again, yung sinabi ko, ano ba yung execution? Execution is yung nag-agree na kayo, nag-sign na kayo na okay. So, binding na yung agreement nyo. So, kung saan pinirmahan, doon yun. Kunwari, ginawa mo dito sa Pilipinas, dito mo tinype, dito mo din-draft yung contract, tapos sa Japan kayo nagkapirmahan. Yung doon dapat nagko-comply yung forms and solemnities of the contracts. Exceptions. Marriage between Filipinos validly solemnized abroad shall be void when under Philippine laws such marriage is void. Kasi nationality principle kapag citizen ka, sinusunod ka kahit saan ka pa. Intrinsic validity of contracts. So, validity is determined by the following rules, the laws stipulated by the parties that shall be applied. Kasi minsan sa kontrata sabihin, the laws of Hong Kong, the laws of Europe shall apply. Sometimes nga, in case of disagreement, hindi, mali yung disagreement, yung ginagamit na yung term. In case of conflict or in case of breach, ganyan, ito yung venue. So, sinasabi pa yun minsan, the case shall be heard in Hong Kong, parang ganyan, or in the courts of Makati, parang ganyan. Sinispecify, or the parties in case of conflict, sorry, hindi mo gana yung utak ko. In case of conflict, like for example, in case of dispute, yun pala, in case of dispute, sasabihin na mag-arbitration muna dito sa Pilipinas, ganyan, or pwedeng mag-arbitration abroad, ganyan. So, pwedeng i-stipulate. Okay. Next is, in default thereof, the parties are of the same nationality, their national law shall apply. Sa intrinsic validity pa rin to. If the parties are not of the same nationalities, the law of the place of the perfection of the obligation shall govern its fulfillment. Or, if the above place are not specified and they cannot be deduced from the nature and circumstances of the obligation, then the law of the passive subject shall apply. Passive subject, yun yung kunwari, debtor at creditor. Yung active subject mo dyan is nakalimutan ko. Active subject mo is yung naniningil, I guess, the creditor. Tama ba? Double check natin. Test natin yung, stock knowledge. Active subject and obligation. Tama! Oh my gosh! So, active subject o creditor, passive subject, debtor. So, kung utang yan, di ba? The national law of the debtor shall apply. Mistake in the application as basis of good faith. A mistake in the application or interpretation of difficult or doubtful provisions of the law may be the basis of good faith and has been given the same effect as a mistake of fact, which may excuse one from legal consequences of his conduct. Pero, tricky to hindi porket di mo naiintindihan yung batas and interpret mo ng mali, okay na. Hindi pwede. Dapat talagang ambiguous din kahit yung courts mismo naguguluhan, 'di ba? Na hindi nila alam, it could be interpreted multiple ways. Ang pangit lang talaga ng pagkagawa ng law. Dun lang siya pwede. Pero hindi pwedeng dahil sa kakulangan ng mental prowess natin and comprehension natin kaya mali yung pag-intindi natin. Hindi siya pwedeng ganon. Kailangan kahit yung mga pinakamatatalino confused. So, ganon. So, when in doubt tungkol sa law, the best thing to do is, of course, ask a lawyer or ask someone who has legal knowledge or do your research, diba? That's your civic duty as a Filipino citizen. You can't hide from the cloak of ignorance, no? Because it's your duty to know the law. laws are prospective. Laws shall not have a retroactive effect unless otherwise provided. So, hindi siya absolutely prohibited, yung retroactivity ng laws. Kasi alam natin sa criminal law, if retroactive laws are beneficial to the accused, then it shall be upheld. In general, kahit hindi criminal law, laws are prospective. But, pwede naman na retroactive siya if the laws specify retroactive application, provided that no rights will be impaired. Next is procedural laws on the ground that no vested rights will be impaired. So, iba naman yung substantive law sa procedural law. Ano ba yung procedural law? Rules of court, mga ganon. Procedure. Laws that grant substantive rights, the law is penal in nature provided that the law is favorable to the accused, save for some conditions such as yung hindi pwedeng mag-avail nito, like habitual delinquency among others. Okay, what else? Interpretative statutes, that's fine kasi in-interpret naman. Lang naman. Curative or remedial statutes and emergency laws. So, again, a retroactive law is one intended to affect transactions which already occurred, something in the past, or rights which already accrued, before it becomes operative, and which ascribes to them effects not inherent in their nature in view of the law in force at the time of their occurrence. So, what are mandatory laws? Laws in which violations thereof tender the act or proceeding illegal and void. Okay. If the law demands something to be done, it is mandatory. When you say naman prohibitory, law which, if omitted, renders the proceeding or acts relating to it generally illegal or void. So the law commands that something should not be done. So what is a right? A right is the power or privilege given to one person and as a rule is demandable to another. I have this power, I have this right, I have the right, I have this privilege, I'm entitled to it, you should respect it. Diba? Ganon, right, meron akong rights, kailangan mong respetuhin as long as hindi siya nag-encroach sa rights ng iba. Kasi lahat tayo may rights. Elements of rights. Active subject. One who is entitled to demand enforcement of the right. Like a creditor. I have the right to demand payment of your debt. Yung sinasabi niya sa passive subject, which is one who is duty-bound to suffer its enforcement or is required by law to comply with something or to do something or to perform something. So, kinds of rights. Merong political rights. So, participation sa government of the state. Right to suffrage, right to run, or to be elected, mga ganyan. Yun yung mga rights mo. Right mong tumakbo, right mong bumoto, mga ganyang rights. Civil rights naman include all other rights. They are further classified into rights of personality which cannot be waived, and family rights which also cannot be waived, and patrimonial rights which may be waived. So yung patrimonial rights lang yung waivable. Real right is a type of patrimonial right wherein the power belonging over a specific thing is without a passive subject. So, as against the world. So, yun yung sinasabing in rem or in re. Diba? So, lupa ko to. Lahat kayo, hindi ko kailangang against sa inyo isa-isa, i-recognize nyo yung right of ownership ko sa property ko. Ganon. Personal right is a type of patrimonial right wherein the power belongs to one person who can demand it from another as a definite passive subject. So, yung utang. Hindi kailangan malaman ng buong mundo na may utang si B sa akin, 'di ba? I-enforce ko lang siya kay B kasi si B lang naman may utang sa akin, wala nang pa kayong iba eh. There is fulfillment of a prestation to give, to do or not to do, and it is also known as jus in personam or jus ad rem. Hindi in rem, ad rem. Waiver, it is the intentional, importanteng intentional. Relinquishment, pagpaubaya. Naalala ko to kasi, kwento ko lang. Okay, i-define ko muna yung waiver. Tas kwento. It is the intentional relinquishment of a known right or such conduct as warrants inference of relinquishment of such right. So yung Tagalog pala ng waiver is pagpapaubaya. Tama lang din. Nalaman ko to kasi sa office, merong mag-aayos ng bubong. Tapos, gagawa namin ng waiver para, syempre delikado yung pag-aayos ng bubong. So, ayaw namin maging liable yung company sa kung anong mangyari sa kanya, diba? Hindi man masama yung company. Ganun lang talaga laging mga ginagawa. May mga waiver yan. Kung ayaw niyang i-take yung risk, edi wag niyang gawin, simple lang. So, medyo parang acknowledgement din sa part niya na alam niya yung pinapasok niya. So, yun. Gumawa kami ng waiver. So, paano nalamang pagpapaubaya siya? Kasi, precisely, dapat yung waiver intentional. Dapat yung relinquishment, yung pagpapaubaya, talagang naiintindihan ng tao na nagwe-waive ng right niya at alam niya yung implications ng pagwe-waive niya ng right. Diba? As in, naiintindihan niya, alam niya, and ginusto niya yan. So, yung waiver na ginawa namin, simpleng waiver lang naman sana siya, pero naging komplikado kasi, guys, tinagalog ko yung waiver. Ang hirap magtagalog ng waiver, ang hirap magtagalog ng agreement. Pero, importanteng nasa Tagalog siya or in Filipino siya kasi, baka sabihin na pinapirma lang namin, 'di ba? At hindi naman talaga niya naintindihan. So, nung ina-fix niya yung signature niya doon sa Tagalog na waiver, 'di ba? Wala nang question na naiintindihan niya kasi yung Tagalog or yung Filipino yung first language niya or yung native language niya. And marunong naman siya mag-read and write, 'di ba? So, naiintindihan niya yung ibig sabihin ng waiver and nire-relinquish na yung right niya. In that case, the right to claim for damages or something. So, waivable rights. Rights may be waived unless contrary to law, public policy, public order, public safety, good morals, and customs, or prejudicial to the rights of third persons whose said rights are recognized by the law. So, rights must be first existing before it may be waived. Malamang. How can you waive something that's not existing? The person having the right must have the capacity to exercise such right in order to waive it. And when the waiver is prejudicial to a third person with a right recognized by the law, such waiver is void. Alleged rights which really do not exist yet are not waivable. And natural rights, like the right to life, cannot be waived. So, ano yung requisites of a valid waiver? Full capacity of the person making the waiver. Kaya dun sa waiver mo, I am blank of legal age. Ganyan. Waiver must be made knowingly and intelligently. Kaya yung sa case namin, kailangan nakatagalog yun. Waiver must be unequivocal, clear. Right must exist at the time of the waiver. It must not be contrary to law, public policy, morals, or good customs. It must not be prejudicial to a third person with a right recognized by law, and when formalities are required, the same must be complied with. So, importante na yung pinapa-waiver mo. Hindi naman na yung waiver niya against the law, public policy, morals, or good customs. So, dapat yung laman ng waiver, pwede mong i-waive, pero meron kang considerations na legal pa rin yung ginagawa mong waiver. Wala kang inaapakang tao sa ginagawa mong waiver. Tama lang din naman yung considerations mo dun sa waiver, merong human considerations pa rin. Hindi siya something appalling or shocking to the senses na parang talagang pag waive niya yan, hindi tama, 'di ba? Hindi siya dapat sapilitan at hindi siya dapat illegal and dapat alam talaga ng nag-waive ng rights and meron siyang right na ganun and may capacity siya i-waive yon. May capacity siya may legal capacity siya na gumawa ng waiver or mag-sign ng waiver. Repeal of law. It is the legislative act of abrogating through or abandoning through a subsequent law the effects of a previous statute or portions thereof. When a law repealing a prior law is itself expressly repealed, the law first repealed shall not be thereby revived unless expressly so provided. When a law which impliedly repeals a prior law is itself repealed, the prior law shall thereby be revived unless the repealing law provides otherwise. When a law which impliedly repeals prior laws is declared unconstitutional, then that's the time the former laws are revived. So, simplihan natin. So, yung repealing law, yun yung subsequent law na inconsistent dun sa former law. So, parang itaksa sa repeal. Meaning, ano na yung mag-a-apply? Ano na yung effective? Ano na yung law natin ngayon? May contradiction. Siyempre, yung most recent, yun yung uphold natin. So, kung express yung repeal, like sasabi, an amendment of, ganito, ganyan, as amended by, mga ganyan. Hindi, when a law repealing a prior law is expressly repealed. Okay, so merong law, tapos merong repeal. So wala na to. Ito na. Tapos may nag-repeal pa dun sa repeal ng law. Okay, ganun yung scenario. 3 laws. The law first repealed shall not be thereby revived unless expressly so provided. So, pag third law, ni-repeal yung second law na nag-repeal dun sa first law, doesn't mean na dahil wala na to, ito na ulit. Hindi. Kailangan sabihin ni third law na, effective na ulit si first law. Unless otherwise provided, it doesn't make the first law that was already repealed by the second law, the third law doesn't make the first law effective again after repealing the second law. Sorry, excuse me. So, ayun. Next, when a law which impliedly repeals a prior law is itself repealed, okay? The prior law, okay, when a law which impliedly repeals a prior law, implied, iba yung express sa implied, explain ko mamaya. Repeals a prior law that is itself repealed, the prior law thereby be revived unless the repealing law provides otherwise. So, dito baliktad, nare-revive siya. When a law which impliedly repeals prior laws is declared unconstitutional, however, then the former laws are revived. Ano ba yung express repeal? One which is literally declared by a new law na, okay, we're repealing that other law. Either in specific terms, as where particular laws and provisions are named, identified, and declared to be repealed, or in general terms. Pag sinabi naman nating implied repeal, it takes place when a new law contains provisions contrary to or inconsistent with those of a former law without expressly repealing them. Low-key lang siya. In order for there to be an implied repeal, the law must cover the same subject matter and the latter is repugnant to the other. Contradictory, kaya siya implied repeal. Hindi niya sinabing repeal siya, pero inconsistent. And syempre, yung later laws, yun yung ina-uphold natin. Implied repeal by irreconcilable inconsistency. So, the law must cover the same subject and the latter is inconsistent with the former. So, what is the operative fact doctrine? The doctrine means that before an act is declared unconstitutional, it is an quote-unquote operative fact, which can be the source of rights and duties. So, dahil nga sa law na yon, nagkaroon na ng effect, diba? So, unconstitutional pala siya, pero nung time na hindi pa siya na-declare unconstitutional, for all intents and purposes, akala ng tao legal yon, so nagkaroon na siya ng effect. So, anong mangyayari doon? The actual existence of a statute prior to the determination of unconstitutionality is an operative fact and may have consequences which cannot justly be ignored. The past cannot always be erased by a new judicial declaration. In short, it nullifies the void law or executive act but sustains its effects. So, yung mga effects doon ng old law na unconstitutional pala, nung time na hindi pa siya na-declare na unconstitutional, for all intents and purposes, it's a valid law. Kasi yun yung presumption, nasa validity ng law. So, yung mga effects doon, wala na tayong magagawa doon. We can take it against the people who relied upon what they thought was a quote-unquote valid law. Pero going forward, hindi na pwede yun, diba? Doctrine of stare decisis. When the Supreme Court has once laid down a principle of law as applicable to a certain state of facts, it will adhere to that principle and apply it to all future cases where facts are substantially the same regardless of whether the parties and the property are the same. So kung similar yung facts, diba, the court will decide the same way. Judicial decisions may be abridged by either contrary ruling by Supreme Court, provided that no doctrine or principle of law laid down by court in a decision rendered en banc or in division may be modified or reversed except by the court sitting en banc. So, the court can also retract the way they interpret statutes or laws. Corrective legislative acts of Congress. Congress cannot, however, alter a Supreme Court interpretation of a constitutional provision, for this would be an unwarranted assumption of judicial power. When a doctrine of Supreme Court is overruled and a different view is adopted, and more so when there is a reversal thereof, the new doctrine should be applied prospectively and should not apply to parties who relied on the old doctrine and acted in good faith. So let's go to the duty of judges. Mahaba pa ba ito? Parang naubos na yung laway ko. Medyo mahaba pa. Oh gosh. Pero kaya natin yan. Okay. Judges are tasked with the dispensation of justice in accordance with the constitutional precept that no person shall be deprived of life, liberty, and property without due process of law. Judges must not evade performance of this responsibility just because of an apparent non-existence of any law governing a particular legal dispute or because the law involved is vague or inadequate. So, if the law applicable to the case is silent, obscure, or insufficient, the judge may apply any rule as long as the rule chosen is in harmony with the general interest, order, morals, and public policy. Among these are customs which are not contrary to law, public order and public policy, decisions of foreign and local courts in similar cases, opinions of highly qualified writers and professors, rules of statutory construction, wait lang. Nagdoble tayo dyan. Okay. Principles laid down in analogous instances, general principles of the natural moral law, human law, and equity, and respect for human dignity and personality. So, yung duty of judges, sabi, di ba, kailangan mag-decide sila pa rin. Kung walang applicable law, they should still decide on the case and say, unfortunately, we can't decide this. Right now, we have to dismiss it because there's no law punishing it. You have to lobby your concerns sa Congress. They still have to say something. They can't say, okay, bye. Hindi pwedeng ganon. They still have to decide on it. They can either dismiss the case or they can for example, there's something heinous, 'di ba, na nangyari pero walang crime, walang law punishing it or considering it as a crime. So they shall acquit the accused, 'di ba? Kasi wala if gusto mo maging crime yan, lobby it to Congress. Parang gano'n. They still have to decide on the matter. Okay, or they can say, walang legal standing, not ripe for adjudication. Okay, so, judicial legislation is when the judiciary is tasked with resolving legal controversies and interpreting statutes the judiciary cannot legislate. Judicial legislation, ginagawa mo, para ka nang ina-encroach mo na yung power ng yung judge or justice, parang ina-encroach na yung right ng Congress na gumawa ng law. Again, taga-interpret lang yung courts. So, hindi sila pwedeng mag-legislate or gumawa ng batas. Laging interpretation lang. Administrative decisions. Although it is recognized that judicial decisions applying or interpreting statutes are part of the legal system of the country, such level of recognition is not afforded to administrative decisions. Effect if the repealing law itself is repealed. So, ulitin natin yung kanina. When a law expressly repeals a prior law, is itself repealed, the law first repealed shall not be thereby revived, unless expressly so provided. When the law which impliedly repeals a prior law is itself repealed, the prior law shall thereby be revived unless the language of the repealing statute provides otherwise. Territoriality principle. Penal laws and those of public security, safety, and order are applicable to those who sojourn in the country subject to treaties and principles of international law. Domicilliary rule. The basis of determining personal law of an individual is his domicile. Nationality principle. Philippine citizens are subject to Philippine laws with respect to their civil status, legal capacity, conditions, and marital and family rights. Aliens are also treated the same way. The laws of their own country govern their civil status, legal capacity, conditions, and marital and family rights. Divorce obtained by a Filipino citizen to sever his or her marriage with an alien spouse is now valid and recognized in the Philippines, regardless of who initiated it. Kasi dati hindi eh. Dapat yung nag-initiate daw dati is foreigner para mag-apply rin sa Filipino spouse. Pero ngayon, nire-recognize na siya. Pero meron niyang mga kailangan kang i-prove sa court and meron niyang mga certain procedures and mga kailangan kang i-submit. Again, yun nga, the court doesn't take judicial notice of foreign laws as a general rule. Adoption processes or foreign judgments involving civil status that are obtained by an alien abroad should be recognized in the Philippines provided that the foreign judgment is proved in Philippine court. Successional rights are governed by the nationality principle except for properties that are located in the country kasi syempre pag real property yan, kung saan nakasituate yung property na yan, dyan yan. Properties are governed by laws where such properties are found. So also applies to movables, hindi lang immovables. Conflict of laws. Conflict of laws is that part of the municipal law of a state which directs its courts and administrative agencies when confronted with a legal problem involving a foreign element whether or not they should apply foreign law. It is fundamentally a problem of choice of law between foreign law and local or municipal law by the forum court with local or municipal law as its starting point. Conflict of laws. Ano apply natin? Itong law na to or itong law ni ganito? If the general law was enacted prior to the special law, the latter is considered the exception to the general law. If the general law was enacted after the special law remains unless there is an express declaration to the contrary, there is clear, necessary, and irreconcilable conflict, and the subsequent general law covers the whole subject and is clearly intended to replace the special law on the matter. General law, for example, civil code, general law. Special law, family code, ganon. So, yung special law, yun yung mag-govern dun sa subject talaga. Diba? Characterization of rules. Characterization in conflict of laws is the process of assigning a disputed question to its correct legal category such as, ano yung mga characterization? Torts, contracts, family law, property law, mga ganyan. It is also known as the doctrine of classification or qualification. So, if the issue in the case is substantive, then if may conflict between municipal law and foreign law, apply the foreign law. If it is procedural, then apply the forum law or Lex Loci. So, guidelines in determining as to whether the matter pertains to substantive or procedural law. Question of evidence, malamang procedural. Prescription of action and statute of frauds. So, ano to? Pag-prescription of action and statute of fraud. So, substantive to kasi it involves, your right to action Phases of judicial resolution in conflict of law problems. So, first, jurisdiction. So, may authority. Authority of the court of law to take cognizance of the case. Next, choice of law. Anong law apply natin or anong applicable law? Third is recognition and enforcement of judgments. So, principle of forum non-convenience. Forum is inconvenient. Yung literal meaning niya. It means that even if the court assumes jurisdiction over the parties and subject matter, it may decline to try the case on the ground that the controversy may be suitably tried elsewhere. So, instances when this principle may be invoked and the court may decline to exercise jurisdiction, sabi ng court, ayaw namin yan, sa iba mo na itry yan. Belief that the matter can be better tried and decided in another jurisdiction either because the main aspects of the case transpired there or the material witnesses have their residences there. Next is to curb evils of forum shopping. Forum shopping, nag-file ka na kung saan-saan, di ba? Court dockets of the forum may already be clogged, and permitting additional cases would hamper speedy administration of justice. Other courts are open, and the case may be better tried there. Inadequacy of the local judicial machinery for effectuating the rights sought to be maintained. Forum has no particular interest in the case. Evidence and witness may not be readily available in the forum, and there is difficulty of ascertaining the foreign law applicable. So what is the What is the long-arm statute? A law that allows a plaintiff to make a claim against a defendant who is a non-domiciliary of a state, provided there are minimum contacts with the forum to justify its exercise of jurisdiction over him. These statutes specify the kind of contracts upon which jurisdiction will be asserted, such as the commission of a tortious act within the state, the celebration of a contract thereto, or the presence of property owned by the defendant if the foreign private juridical entity is not registered in the Philippines or has no resident agent but has transacted or is doing business in it, as defined by law. Service of summons may, with leave of court, be effected outside of the Philippines. Medyo madami-dami pa to kasi conflicts of law, pero kailangan siya sa general principles of coverage siya dito. Minimum contacts test. Okay. Dito ba ako nag-stop? Oh my God, wala na ako. Yes, minimum contacts test. Provides it Hindi, tapos na ako niyan. Doctrine of Fundamental Fairness. It serves to protect citizens generally against unjust and arbitrary governmental actions, and specifically against governmental procedures which tend to operate arbitrarily. It serves as an augmentation of existing constitutional protections or as an independent source of protection against state action. Okay. This doctrine appropriately applied in those rare cases where not to do so will subject the defendant to oppression, harassment, or egregious deprivation. Scrivener's error. It is the failure of the agreement to express the intention of the parties due to wrong terminology, missing details, or clerical error. Because there is failure to express the true intent of the parties, the agreement is interpreted according to its plain or obvious meaning. Ito, very common, renvoi, or referring back doctrine. The court of the forum, in resolving the question before it must take into account the whole law of the other jurisdiction, including its rules as to conflicts of laws, and then apply the law to the actual question which the rules of the other jurisdiction provide. So the application of the foreign law in the country may be prevented if the foreign law itself throws back, referring back, the question of the law of the domicile of an alien decedent residing in the Philippines. So for example, succession, tapos sinabi, tapos Japanese yung namatay dito sa Pilipinas. Nationality niya yung masusunod, diba? Nationality law niya. So, laws of Japan. Pero kapag yung laws of Japan, pag binasa mo naman yung sinabi, the laws kung saan siya namatay, yun yung mag-a-apply. Saan siya namatay? Sa Pilipinas. So, ano yung mag-a-apply na law? Yung law ng Pilipinas. Bakit? Hindi dahil namatay siya dito. Dahil Japanese siya. And according to Japanese law, yung law na mag-a-apply is yung law kung saan siya namatay. So, ganon. Binalik lang. Ganon. The parties may waive the application of the renvoi doctrine. Renvoi ba to? Renvoi? Hindi ko alam. Renvoi, siguro, I feel. The application of the renvoi doctrine to prevent complications. Rules of private international law will find no application once a foreign law is chosen by the parties. Desistment theory, also known as the mutual disclaimer of jurisdiction theory, which states that the forum court, upon reference to another state's law, sees that such law is limited in application to its own nationals domiciled in its territory and has no provision for the application to nationals domiciled outside of the territory. Hence, the local court will apply the local law. This has the same results as the acceptance of the renvoi doctrine, but the process used by the forum court is to desist applying the foreign law. Transmission theory. If the foreign law refers it to a third country, the said country's law shall govern. Hindi third world na. Third country, pangatlong country. Damage. Damage is the recompense for the damage suffered. Abuse of right. The principle of abuse of rights departs from the classical theory that he who uses a right injures no one. The modern tendency is to depart from the classical and traditional theory and to grant indemnity for damages in cases where there is an abuse of rights, even when the act is not illicit. So requisites for claiming damages against the abuse of right doctrine: abuse of right is actionable. Meaning, pag may nakita kang nag-aabuso ng rights na, you can file for damages. The right of a person ends when it interferes with the right of another according to this doctrine. Before one may claim damages by virtue of the abuse of right doctrine, ito yung requisites. First, there must be a legal right or duty. Second, it was exercised in bad faith. And, hindi pwedeng mag-stop lang doon na meron siyang right tapos naabuso niya yung right niya. Dapat affected ka para makapag-file ka ng damages. So, na-injure ka. Yung abuse of right niya nag-result sa prejudice mo. So it is for the sole purpose of prejudicing another. Even if not under the abuse of right doctrine, one may still claim for damages if a person willfully or negligently causes damage to another and shall indemnify the latter of the same. Even if the act is not contrary to law, any person who willfully causes loss or injury to another in a manner that is contrary to morals, good customs, or public policy shall compensate the latter for the damage. So, hindi kailangang crime. Breach of promise to marry, however, in a case, is not actionable wrong, except for cases like in Vasmar versus Veles, because of the expenses or cost of the wedding. Kasi, gumastos na daw sila eh. So, hindi siya simple breach of promise to marry. Basahin nyo na lang yung case na yun. Yung nangyari doon kasi, parang umuwi siya sa probinsya nila before nung day ng kasal. Sabi nga babalik siya pero hindi talaga siya bumalik. So lahat na ng preparations, lahat na ng gastos, 'di ba? Tapos napahiya pa. So hindi lang 'yon simple breach of promise to marry. So, exercise of rights. The exercise of right must be in accordance with the purpose for which it was established and must not be excessive or unduly harsh. There must be no intention to harm another. Damnum absca injuria. Damages may only be claimed if there is a legal wrong committed or legal injury caused. The doctrine states that even if there is damages, if it is not caused by another by willfully committing a wrong or causing an injury due to negligence or omission, the latter is not liable. Contra bonus mores. Any person who willfully causes loss or injury to another in a manner that is contrary to morals, good customs, or public policy shall compensate the latter for the damage. Unjust enrichment. No man must be unjustly enriched. A man unjustly enriched must return what he unjustly received to the rightful owner. The following are its requisites. First, a person must have been benefited without real basis or justification, and second, that the benefit was derived from another person's expense. So, equity is a principle that applies even in cases of unjust enrichment. One who loses money or property by knowingly entering a contract that cost his or her losses cannot be actionable. So, kailangan may right ka to it, tapos may someone there na unjustly enrich at your expense. So, diba? Kunwari, nag-deposit ka. Tapos, for some reason, napunta sa account niya. Diba? So, that's unjust enrichment. Or, nag-book ka ng something. Tapos, kinain ng tapos hindi dumating yung delivery mo. Parang mga ganyan. At your expense, hindi yun fair. Equity. Yan. Basically, ganun. And, before I end this episode, I'm just gonna look for the provisions in New Civil Code. Kasi, I remember, Dean Maita Gonzaga once said that when you're taking the bar, there are 3 provisions of the Civil Code that you should memorize down. Kasi this could be like your, yung kakapitan mo. Okay. And let's memorize it together. Okay, nasa na yan. Ito yung pinaka-importanting provisions daw. Okay, Article 19 of the New Civil Code. Every person must, in the exercise of his rights and in the performance of his duties, act with justice, give everyone his due, and observe honesty and good faith. Article 20. Every person who, contrary to law, willfully or negligently causes damage to another shall indemnify the latter for the same. Article 21. Any person who willfully causes loss or injury to another in a manner that is contrary to morals, good customs, or public policy shall compensate the latter for the damage. Okay. So, yan. Yun yung tatlong importante. Importante naman lahat. But, So, sa next video ko, start tayo sa persons. Okay. Rest muna ako. Bye. See you.